All right, welcome back. This is the second lecture on the category of properties in your property law lecture notes. Basically, you would see that in this slide we cover division of property. So property is talking about real property, land or realty, and personal property, like everything else, phones, mobile phone, everything, cars that you own. Categories of personal property. Chattels, personal. Chattels are choices in or things in possession, choices or things in action. The PNG sort of Sale of Goods Act 1951 deals with transactions relating to goods defined as chattels, rather than things in actions or money. All right, chattels real and chattels leasehold. All right, so when you talk about these things, you know that there are choices in possession. Choices in possession, okay, the first characteristics that it has is tangible personal property, and it's sort of another word they use, or it's synonymous with goods and chattels. So there are three characteristics of choices in possession. It must be tangible, capable of physical acquisition, and movable. Example, pen, car, books, clothes, etc. Okay, choices in action. These are what you call, it's something that's enforceable by action. It may be used to describe the right of the action itself when considered as part of the property of the person. Example, entitled to sue. The right to sue for a sum of money is a choice in action and is a proprietary right. All right. For instance, if you default on a loan, when you get the bank has that right to sue you. So that right allocated to the bank is by way of a contract, a loan agreement, and it's called a choices in action. That is different from a choices in property. Choices in property is something that you can see, car, pens, books. Choices in action is a abstract right there. So when you get a loan, the bank have an inherent right to sue you for that sum of money. And that sum of money is a choice in action. I hope that's clear. Right, choices in action, enforceability by the right order against the duty holder. Incorporeal tangible, it's an immutable legal object. And without any coefficient or entitlement. Example, the right to recover debts or shares in a company. All right, chattels real. Chattels reals, you see leasehold. Basically, it has a dual nature, so it's a leasehold interest is a personal property, and then it is treated as contract. Basically, a leasehold is sort of a interest in property. All right, so I've just given you a graph to sort of how the distribution of property sort of gets along. So property, personal, real, and then in personal, you'd have chattels personal or chattels real, and then choice in action and choice in possession and choice in action. All right, fixtures. Now let's look into fixtures. What is fixtures? A fixture is a chattel, like a personal property, but becomes a real property when it becomes a fixture. So when it's attached to the land. So an object which was once a chattel, but which has become in law land because it has been affixed to the land. Two tests that you give annexation, purpose of annexation. For instance, a house is not a chattel, it's a fixture because it's annexed to the land. Right, if the chattel is attached to the land at its own weight, it is a prima facie fixture, even if the degree of annexation is very slight. And then you see purpose of annexation test. Its case indicates the intention with the degree of annexation observed. So basically, in explaining it, it says that if something is sort of inbuilt onto the land, like a house, or even there's all the little materials that make up the house, like the door, the windows, the tiles, everything are chattels. But when it becomes attached to the house, put together and completed, when you complete the house, you see that it now becomes a fixture. All right, and then there's a test that it's given there. If it's attached to its own weight, I'll give you a classical example. And then also you could see that there's a difference between fixture and chattels. All right, in another slide, I've given you sort of basic rundown of how to acquire rights to property through conveyancing. Right, conveyancing is a legal process of transferring title of a property from one party to the other, so a buyer to a seller. And basically, these are the steps that happen. So before executing the contract for sale of property, the buyer should already have the necessary finances available. So you got to have the money to pay for the property. So when that happens, if this property is, for example, if it's like 500,000, they said that you pay a 10% interest upfront and you sign the contract. So you pay what, 10% of 500,000? I think it's 50,000. Yep. You pay 50,000 and the lawyers will prepare 3 contracts of sale. You both sign them. And then you get the contract if you're a first-time home buyer, you get the contract, you take it to IRC. And then IRC basically gives you exemption from stamp duty. So when the contract is executed, you pay the 10% value. And then lawyer will stamp it, sign it to IRC. After process, you make the registered money available. It goes to settlement. Settlement is where the buyer, the transfer instrument with title is given to the buyer to change title. If cash purchase directly, changes to buyer. So they change the name from the seller to the buyer. If through a mortgage, that will be transferred to the buyer, but held by the bank as the mortgager. So also during settlement, all outstanding sewage, garbage, and land tax rates will be settled from the purchase price. All right. How to acquire rights to property through conveyancing. If you own property, the land is demarcated according to lot and specific portion numbers, part of a state lease. You would see that the first thing you do is to settle search. Then you see the type of lease and the property under, section and lot number, and who is the current owner, and then the history of the property's ownership. After title and person selling has been confirmed, the transaction shall proceed. If the buyer is a cash purchaser, there is no need for bank loan. However, in PNG, many buyers get a mortgage with a bank to buy properties. All right, properties acquired under custom. You would know that the law of PNG custom recognizes property owned under custom. Property can be owned and transferred under custom PNG. For instance, in the villages and your houses of customary land are owned under custom. You can also give the land and house away to anyone under customary practices. When there's a land dispute over customary land, they're dealt with at the local land court under the Land Dispute Settlement Act. All right, this is the second part of the lecture. In your next lecture, we look at property law lecture 2 and lecture 3 to complete the lectures. Thank you.